In general, the word download can be defined as an act of copying data from one computer system to another, typically over the Internet. Whereas, the definition of data logging is the process of using the computer to collect data through sensors, to analyze the data and output of the results of the collection and analysis. Data logging also implies the control of how the computer collects and analyzes the data. Lastly, the definition of Internet capture is any method of collecting information and then changing it into a form that can be read and used by a computer. In a broad sense, download is an act to transfer data. Data capture is a process to collect information, whereas data logging is to analyze the data and information obtained. When a movie or song is produced and marketed, everyone involved in the process has monetary gains from the sale of that product. Therefore, that product is protected by copyright law so that it cannot be copied, reproduced or resold without their permission. If you did not pay for a song, movie or other media file that has a copyright, then downloading that file is a crime. Likewise, distributing a copyrighted media file, whether via electronic or non-electronic methods, without the express permission of the copyright holder is also illegal. Not only illegal download that makes the most concern under the law in Malaysia, but also the downloading of obscene material from the Internet in the country. In the Film Censorship Act 2002, the Malaysian legislature has enacted a special provision to prevent the spread of obscene materials in this country. In Section 5 of the Act, it states that no person shall have or cause himself to have in his possession, custody, control or ownership any film or film publicity material which is obscene or is otherwise against public decency. Any person who contravenes the provision commits an offence and shall be liable on conviction to a fine of not less than 10,000 ringgit and not more than 50,000 ringgit or to imprisonment for a term not exceeding 5 years or to both. Based on new statistics made by Google, around 2.5 billion emails that contain obscene material sent every day around the globe. It is easier to understand what is going on, and we need this explanation if we are to understand some of the problems of evidential quality, by looking at the more generic forms of computer communications software. An important feature in computer communication software, especially significant to the issues of evidence collection, is logging. In general, logging activity opens up a file on the user's computer which records all characters received by the terminal. It is often possible to play back a previous online session, hence the potential value as an audit trail. There are, however, some limitations on the logging capability. First, the starting and ending of any log file is wholly under the control of the PC user, so that the provenance of any log file and its admissibility have to be separately established. Secondly, the log file can also be sent directly to a printer, and this may have some value in terms of preserving the evidence. However, here the problems of junk characters are even more acute. In addition, at a purely operational level, if the printer log is truly simultaneous, the overall speed of receiving characters from the remote computer will be reduced to that of the printer. which will inevitably be slower than when characters are merely displayed on screen and recorded to disk. For example, in the case of Matthew First against Grant Raphael, the claimant based his argument merely on a hearsay statement and activity log obtained from the defendant's computer. The activity log shows all the activity on Facebook on 19th and 20th June of 2007 from defendant's IP address. That shows his record of usage of the computer in his house as well as the Facebook activity log. The judge admitted all the evidence of activity log adduced before him. The plaintiff first discovered the false profile and group page by accident and immediately alerted Facebook, who removed the page. Through his solicitors, claimant obtained an order against Facebook for disclosure of the registration data provided by the user responsible for creating the false material. The data included email addresses and the IP addresses of all computers used to access Facebook by the owners of those email addresses. A forensic study of this information led to defendant. After the case done, Facebook began handing out personalized web addresses on a first-come, first-served basis. The move allows users to create a distinct online address for their personal profile with a name of their choosing, such as facebook.com/shillings. It also lets them use their Facebook page like a personal home page. Facebook said that within 15 minutes, 500,000 users had registered a personalized web address. The following are Miller's general tests for the reliability of a computer-derived evidence. It must be shown to the court that the evidence complies with these three requirements. First, the evidence must be authentic and the evidence is specifically linked to the circumstances and persons alleged. Second, the evidence must be accurate. The evidence must be free from any reasonable doubt about the quality of procedures used to collect the material, analyze the material if that is appropriate and necessary, and finally to introduce it into a court, and produced by someone who can explain what has been done and what actually has happened. Last but not least, the evidence must be complete. The evidence must tell within its own terms a complete story of particular set of circumstances or events. We also have to distinguish between the conventional evidence and computer-related evidence. There are so many elements which set computer-derived evidence apart from other types of evidence. Computer data can change moment by moment within a computer and along a transmission line. Many forms of conventional evidence are claimed to be a snapshot of a particular sequence of circumstances, but the problems are particularly acute with computers and technological devices. This can create considerable difficulties over authentication as to content and time of creation. Secondly, computer data can be easily altered without leaving any obvious trace that such alteration has taken place. As a comparison, alterations in handwritten and typed documents are usually self-evident. Another example, log and account books which are designed in a certain way so that it is easy to detect if an entry or page has been omitted. However, computer-based documents can be forged with an ease and freedom from detection which is of a quite different order. It is of course entirely possible to design a computer system which prevents certain forms of unauthorized alteration. But, in contrast to paper-based books of account, There are very few obvious standards which set a measure of what to expect from computer-based evidence. Many immediate computer evidence is not obviously readable by the humans. The evidence stored in a computer is usually in a form of encrypted computer language which is complex and not reader-friendly, whereas actual evidence are often derived, manipulated and presented away from their point of origin. This becomes apparent as soon as one argues that the computer evidence is just merely the record or document produced by a computer. There is nothing wholly unique about this. For comparison, the typical DNA trace is not DNA itself but a representation in a different form which can complement the DNA analysis. The particular problem in relation to computer evidence is the large number of possible and potentially accurate representations of original computer data that can exist. What is seized may be a computer disk which contains large numbers of directories of files of various kinds, while what is put immediately before the court may be just a print out or screen dumps. The large variety of possible representations of original material makes difficult the evolution of standard of proof for computer evidence. Last but not least, computers create evidence as well as record and produce it. The traditional manually maintained books of account consisted of sheets of paper into which handwritten or typed entries had been made. Subsequent calculations were also substantially manual, even if a simple calculator was employed for some of the stages. But in the computerized equivalent, it is only the original entries that are manually input and all the other records are produced by the computer. There are many examples where computers assemble documents and only do so at the point at which a request is made for the document to be created. This can be true of online requests as well as conventional print out or on-screen as trade between fast emerging markets accelerates and development of new emerging countries. Information and communications technologies have the potential to provide new solutions to development challenges, particularly in the context of globalization. Undoubtedly, people will become more dependent on the technology than before, and the integration between law and technology will apparently become more imminent from day to day. However, it is not an easy task to adduce computer-related evidence before the court. There are many elements to be proved and many requirements to be fulfilled, but it is not possible as long as it complies strictly with the evidence rule and its procedures.